The Mahoning County Board of Elections will hold a special meeting of the members of the board on Thursday, August 15th, 2024, at 8:30 a.m. in the board meeting of the Mahoning County Board of Election Office, 345 Oak Hill Avenue, Youngstown, Ohio, 44502. This hearing agenda item is incorrect. For an inquiry hearing for a seat and a petition of Mr. Fisher. Would the director call the roll, please?
Ms. Barger?
Yes.
Attorney Beatrice?
Yes.
Mr. Orange?
Yes.
Ms. Delpesta?
Yes.
Would the vice chairwoman of the Board of Elections lead us in the Pledge of Allegiance?
I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I would ask for a moment of silence, especially for my son, whose now whereabouts are unknown. For the audience, he's an Army Ranger, so he just left. I want to, thank you. I want to check item number 4. This technically isn't considered a protest hearing. This is technically considered an inquiry by the Board of Elections regarding the petitions of Tex Fisher, because it was brought to the board's attention that there may have been problems with his nominating or his petition or his replacement to be put on the board or on the ballot. And this board has a statutory duty to look at the sufficiency of nominating petitions or of however someone gets on the ballot. This board has an obligation. We all took oaths to follow the Constitution of the United States, to follow the laws of the state of Ohio, and to follow the laws of the Constitution of Ohio. This board is technically supposed to act in a bipartisan manner, and the purpose of today, and we have a court reporter here. I missed it.
Hi.
Thank you. The court reporter is here. So in the normal parlance of human interaction, we communicate by nonverbal means. Since a court reporter is here, she cannot take down nonverbal communication. So anyone that is speaking must speak out loud. You can't shake your head up and down or yes or no. You must audibilize every answer. So wherever this winds up, we have a complete record. We have allotted 1 hour for us to determine some of the issues that have arisen. And if it runs over the hour, that's okay. I'll just have Tom McKay call the judge and tell that judge I'm going to be late.
Depends on the judge.
Judge Sweeney.
I can call it.
Okay. And so, how I thought we would run this is, we would give each side a half hour. If they don't want to use their half hour, that's okay. If they do, they can. And then if you want to run over or you want to say something, if you want to give rebuttals to each other, I want this to be a fair inquiry. I want the record to be complete. I want everyone to feel that they've had their say, so this board can do what it is statutorily obligated to do. Before we take or start take anything in, is there anyone that's going to be testifying? No one's going to be testifying. Therefore, we will start with, does the board have a preference of which?
We have someone who's going to testify.
Okay, would you come to the front, sir?
I'm sorry, I didn't hear.
Would you raise your right hand? Do you solemnly swear, what's your first name?
Dave
Dave, and your last name?
Skripek,
Did the court reporter get that? And where are you from?
Canfield.
Canfield. Do you solemnly swear that any testimony you're about to give will be the whole truth, if nothing but the truth. This you do under, as you swear to God, or under the penalty of perjury under the state of Ohio.
I did.
Thank you. So, does the board have a preference on which side we would like to hear from first?
Guess I would like to hear from Mr. Anderson first, since you made
Or
The
his
letter.
counsel?
or his counsel.
Okay, so there's a motion made by Vice Chairwoman Sandra Barger. Is there a second? Second. Is there any discussion or concern? I'm only gonna say, since I'm gonna give each side equal time and they can rebut and do whatever they wanna do, so we have a full record. I don't think it matters, so would the director call the roll, please?
Ms. Barger?
Yes.
Attorney Petrus?
Yes.
Mr. Arch?
Yes.
Ms. Calpesto?
Yes.
Okay, Mr. Anderson, do you have counsel representing you?
Yeah, this is Attorney Corey Columba. He'll be speaking on our behalf.
Corey, would you like to come up front, please?
Yes.
Sure.
Mr. Chair, should I stand right here?
Yeah, you can stand right there. Could you
Okay.
spell your last name for me, please?
Sure. Last name is Colombo,
You guys-
C-O.
You're in the
Oh,
camera.
I'm-
Go ahead.
Why don't you stand right there?
I'm not skinny either, so there's no good way to get around it. Yeah, first name is Corey, C-O-R-E-Y. Last name Colombo, C-O-L-O-M-B-O. I'm with the law firm of Latag and Colombo in Columbus, Ohio.
And can I have your address, please?
Yes, it's 545 East Town Street. That's in Columbus, 43215.
Mr. Colombo, the floor is yours. I'm gonna set my timer for 30 minutes. You don't have to use the whole 30 minutes. I'm assuming Mr. Fisher has an attorney here. I'm just gonna tell his counsel that I'm gonna let you guys go back and forth. Do you feel that we've had enough information to make an informed decision? But your first presentation will be limited to 30 minutes.
Thank you, Mr.
You can begin now.
Thank you, Mr. Chair and members of the board. Thanks for your son's service. It's appreciated. As you mentioned in the intro, I represent Chris Anderson. He filed the objection on August 12th with the board against Austin James Texford Fisher's candidacy. Mr. Fisher's running for the 59th District State Representative, and this inquiry deals with revised code section 3513.271. A copy of that statute was provided with the objection letter. And as indicated on that exhibit, this law has been in effect since 1995, so for nearly 30 years at this point. Mr. Fisher legally changed his name on May 19th, 2020 in the Mahoning County Probate Court. And that was also provided to the board in the objection in Exhibit B, so.
Well, before we begin, so the court reporter has it, I would like to mark these as exhibits. So what is the first exhibit you'd like us to mark?
Yeah, so I'm relying today solely on the objection letter, and that was filed August 12th.
Here. With the email.
I believe it was emailed to the board.
So we're gonna make this exhibit A, and so I can correct the record. This is not a protest hearing. It is an inquiry by this board of an issue that was brought up to us. We have an obligation to check the sufficiency of petitions and nominations. And so this board had questions, so it's an inquiry. So I'm gonna hand this to the, do you hand it?
Yes.
So she can have that on the record. This is exhibit A is,
Mr. Chair, can I
Yeah.
make a recommendation? Can we make this Exhibit 1, just for the fact, Exhibit 1 has Exhibit A, B, and C.
okay, do you have them pre-marked for me?
I didn't bring, since the board already had a copy, I didn't bring an extra copy.
Okay, so what would exhibit 1 consist of?
Exhibit 1 would be the August 12th, I'm going to call it an objection letter, essentially, that triggered this inquiry. So it would be the August 12th letter from Mr. Anderson.
Okay,
And then if we could,
There's an appendix A to it, and an appendix B to it, and an appendix C to it.
That's correct.
Is-
So,
Would you hand that to the court reporter so she has it for the record,
I would,
please?
thank you. So as indicated, Exhibit B shows there was a name change of May 19, 2020, so less than 5 years ago. In the objection letter cites to 3513.271, and that was attached as an exhibit as well as Exhibit C. This section states quite clearly, if any person desiring to become a candidate for public office has had a change of name within 5 years, immediately preceding the filing of the statement of candidacy, both his statement of candidacy and nominating petition must contain, immediately following the person's present name, the person's former names. So the last exhibit that I haven't referenced yet is Exhibit A. So it would be 1A, I guess. And this is the Form 289 that was filed with the board on August 7th. And if you look at that form, and I'll go back to this in a minute, but a Form 289 is a form that was prescribed by the Secretary of State's office. It clearly has in the title the word nomination, and it clearly has the word statement of acceptance. So this replicates, this form is filed when there's a replacement candidate. The initial candidate would have filed a similar type of statement and petition, and now it's the party who has a form where they're submitting the candidate's statement and a petition. They're petitioning the Board of Elections to put this candidate on the ballot. The name that was chosen for this Form 289, as you can see on Exhibit A, is different than the name that Mr. Fisher used 5 years ago. Specifically, 5 years ago, he did not have the name Texford in his legal name. So instead of putting in parentheses his new name and then the name without Texford, it only provides the name as it is known now, not how it was known over 5 years ago. To give some recent history on how these laws have been applied, in just this year, 2024, 3 LGBTQ candidates were not certified to the ballot because they did not include their former names on their paperwork, on their petition to the board. At that time, Secretary of State Frank LaRose said, "It is important for people to disclose who they are and any former identities so the voters know who is asking to be put on the ballot." At that time, the 3 boards that grappled with this issue said that they were confined to following the law and recommended they couldn't make exceptions, that the candidates' remedies were at the General Assembly. If they wanted to go on the ballot, they have to change the law. The board can't change it for them. And I'm paraphrasing because there were 3 different boards involved. At that time, earlier this year, the boards of elections all said the same type of reasoning, and that is that there are only 2 legal exceptions in this law. And that's by if your name changed by reason of marriage, and that's the first exception to the law. The second is if they have previously been elected and complied once with the law, so they've already been through an election cycle with their new name. Neither of those exceptions apply here, as Mr. Fisher's name was not changed due to marriage. He has not run with that former and current name on a prior election. So if an exception was not created for members of the LGBTQ community, the board should not create an exception here today for Mr. Fisher. Also at Tuesday's hearing, the chair properly cited to a recent Supreme Court case on these laws. It was the Ari Gold Supreme Court case from 2003. In that case, Mr. Gold legally changed his name through the citizenship process. Legally changed his name, and In that case, the Board of Election would not make an exception either, citing there's only 2 ways that a candidate would not need to list their former name. So the Supreme Court said the law is unambiguous. They said the intent behind the candidate's use of a different name is not relevant. And the Supreme Court declined to add an exception for a name change due to the citizen process. So now in the last year or two, we've had courts, we've had boards not making exceptions for perfectly legitimate reasons to have a different name. You know, transgender candidates changing their names, changing your name to citizenship. Neither of those situations persuaded the legal authorities that they should create new exceptions. Now you might ask, does it make a difference that a name was added to a former name, an already existing name? Well, the law does not distinguish whether a name was added, modified, altered, removed. There's no language in there. It's very black and white if there's been a name change in the last 5 years. And the bottom line is Mr. Fisher did go through a legal name change in the last 5 years. I've never met Mr. Fisher before. I'm not sure of his motivations or intentions for deciding to add Texford to his name. It could have been, it likely was pure intentions. Or maybe it was a nickname that he just wanted to make part of his legal name. But whatever the reason, it really doesn't matter. It's still a name change. And I can relate, in my family, I have a father and brother with the same first and last name with a different middle name. And I can assure you that if one of them added the name Texford to their existing names, people would make the assumption that's not one of my relatives. So adding the name, as opposed to revising it, removing something, it's still a name change and gives a person a new identity, a new way of being known. It could be misleading in some instances. The law doesn't provide for election officials or courts to analyze the reasoning a person changed the name. The law also doesn't allow election officials to analyze how different the names are. So, you know, Mr. Fisher's names may be a little more distinct than common names like Smith or Jones, but what if someday the board gets a case where John David Smith becomes John David Texford Smith? You know, so there's not, the law is just clear. If there's a name change, there's a name change. Include both names on the petition. There's also another section which I don't believe was brought up at Tuesday's hearing, and that's Revised Code 351302. Again, that's 351302.
Do you have a copy of that section?
I do back of my materials.
Annie, can you make a quick copy of that for us, please?
I apologize, Mr. Chair, I didn't come with extra copies. And and while she's copying it, I can read it verbatim, the whole section.
And this section is 35.
Yep, 3513.02.
Okay.
And this is important as the sections all relate to one another, because 351302 states, any former names which have been declared or submitted in accordance with this section, 351306 of the Revised Code, shall be printed on the ballot in parentheses directly below the present name of such person. So this is why it is important. Not only is, the first step is a petition was filed with the board to change the name of the candidacy, and that's the Exhibit A, Form 289. It has the nomination component, it has the statement of acceptance component. So that's step one, that's important, but it's also important for the law that the board is provided with the former name as well, because the board will take the name with the former name and put them both on the ballot if there's been a name change in the last 5 years. So if this information is not conveyed on the submitting document, the petition, which is a petition, you know, in every sense of the word, petition's not necessarily defined in the Revised Code, so it's basically anytime you petition the government, petition the Board of Elections. So the section cited in the objection goes hand in hand with 35-1302, that the board needs to be provided the former name to print on the ballot. In this case, it's the addition to a name, so the former name would have the absence of the new name, which is what the voters should be provided with on the ballot. Thank you, sir. It protects the voters to know any name change from the last 5 years. And so in other words, the addition of the name Texford is different than how his name was 5 years ago. So it would not be logical, I guess, to treat different forms of petitions, whether it be a Form 289, a nominating petition, a declaration of candidacy. The law should apply equally, that any type of petition submitted to the Board of Elections needs to comply with the law. In short, my client requests that Mr. Fisher's name not be certified to the ballot as a candidate for the 59th district. Without having witnessed today, I didn't need 30 minutes, but I would like to reserve any unused time for closing or to address arguments raised by Mr. Fisher's counsel, and I'd be happy to take any questions you have.
What I'm gonna do is I'm gonna let both of you make a presentation, and then I have a series of questions for both of you, but I wanna hear both presentations before I ask the questions. Does the board have any question for Mr. Colombo? No. You used 14 minutes and 9 seconds, but as I said, we're not gonna strictly hold to that. I want both sides to feel that they have ample opportunity to present with us whatever information they feel we should have, so we can make an informed decision. And so now we will hear from Mr. Fisher's attorney, I'm assuming.
I'm Kurt Hartman, with the law firm Kurt Hartman out of Cincinnati, here on behalf of Mr. Fisher. Mr. Chairman, I'm giving you my business card with my address and contact information.
And I'm gonna pass that to.
She already has one.
She has one, beautiful. That's a trial lawyer for you.
Okay. And I'll try to beat Mr. Colombo's 14 minutes that he used and see if I can maybe do it in 10. Since the board is proceeding as an inquiry and not as a formal protest hearing, I've got a kind of a summary of my arguments to aid the board in this and kind of go through the process that is involved, and that is actually that this inquiry raises. I think when the board needs to proceed kind of and appreciate certain overriding principles at the outset. That first, that election laws must be construed liberally in favor of persons seeking to hold public office and to avoid restricting the right of electors to choose from all qualified candidates. And therefore, courts and this board, if it's acting in a quasi-judicial capacity, must avoid unduly technical interpretations that impede the public policy favoring free and competitive elections. In addition to that principle, there's also another overriding principle that political parties are entitled to have a candidate for each office at the general election. And these are principles pronounced by the Ohio Supreme Court, and I've got the case cites there for the board. And therefore, a political party has the right to replace its nominee, that is the person who won the primary election, under 3313.31B, when you involve a multi-county district, in which this seat does. And so, if you look at 3513.31B, it says, if a person nominated in a primary election as a party candidate for election at the next general election withdraws, which has occurred in this case, the vacancy in the party nomination so created may be filled by a district committee of the major political party that made the nomination at the primary election. And so in this case, with the State House, it was the Republican Party through the primary election that made the nomination. And that became the candidate withdrew, and so the party is filling its nomination. Consistent with the principle that the political party is entitled to have a candidate for each office at the general election. And it is through Form 289 that the political parties designate who fills their nomination. And therefore, under 3505.03, the Board of Election actually has the legal duty to print on the office type ballot at the general election the names of all candidates who were nominated at the most recent primary election as candidates, and the names for all candidates for election who were nominated by nominating petitions. And in this case, the inquiry, or what Mr. Anderson characterized as his protest, really demonstrates a fundamental ignorance regarding the actual electoral process by which individuals' names appear on the ballot. A candidate's name does not appear on the ballot simply by their own fiat or their declaration. Instead, a person's name appears on the general election ballot through a nominating process. The names appear on the general ballot through a nominating process, and there's two ways that individuals can be nominated so that their name appears on the general election ballot. First way is by obtaining the nomination of a political party. First, obtaining the nomination of a political party, and that is done either by winning the primary election, where you then become the nominee of the political party, or if the original nominee withdraws, by the nomination being filled by the political party pursuant to 3513.31, which is what happened in this case. The second way a candidate can be nominated to run in the general election, and that is as an independent candidate, because they're not getting the party's nomination. The way an independent gets nominated is by filing a statement of candidacy and a nominating petition with a sufficient number of valid signatures. Those are the two ways names appear on the general election ballot. Through the party nomination, winning the primary, or being designated when the person withdraws, or by filing a statement, which the law, the revised code characterizes as a statement of candidacy and a nominating petition, and we'll address that here shortly. Even though this may not be relevant to the issue here today, I want to kind of go through those two processes. First, there's the way of obtaining a party's nomination. And so when the candidate says, I want to seek my political party's nomination through the primary election, Revised Code 3513.05 declares each person desiring to become a candidate for a party nomination at a primary election shall file a declaration of candidacy and petition. Those seeking not parties to win the primary, to be a candidate in the primary for their party's nomination, files a declaration of candidacy and a petition. That is the language the Revised Code uses. And then 3513.07 sets forth that the form of the quote-unquote declaration of candidacy and petition of a person desiring to be a candidate for a party nomination is set forth in substantially the following form, set forth in the code. Mr. Colombo said there is no thing about what is a petition. It is. For the party nominations, it's in 3513.07. So when one sees...
Wait, hold up a second. You just threw another section at us.
3513. It's a long section. I summarized the pertinent portions here at the top of page 3 of my memo.
I would just like to, but you don't have a copy of that revised code section.
I may have a single copy.
We can get copies of it.
3513.07.
Would you have anything else to make a copy of that?
Hang on, let me go get more. Probably a few more I have to pull out.
That's all right, take your time. Each side has cited a statute section, and not that we don't trust what you say that they say, I want the board to have the actual statute in front of them so they can read it themselves.
Yes. Hopefully I won't kick that over. So basically through this process, when one seeks a party nomination by filing a declaration of candidacy and a petition, the form which is set forth in 3513.07, the candidates use what the form 2F as published by the Ohio Secretary of State. And I've got an excerpt of part of the form there, where you can clearly see in Form 2F, the top portion is declared a declaration of candidacy, where it says, I, the candidate's name, hereby desire, etc. Then the second section, where you start getting the individual signatures, is entitled Petition for Candidate. So that is consistent with the law that says if you want to seek a party's nomination at a primary election, you file a, quote, declaration of candidacy and petition. And that is where section 3513.06 comes into play that says, hey, if you have a former name within the past 5 years, immediately preceding the filing of the person's declaration of candidacy. Declaration of candidacy is there on Form 2F. It says the person's declaration of candidacy and petition, i.e. Form 2F, shall contain both immediately following the person's present name. Then there's a situation we have that is invoked in this case, which I don't really think is even applicable, is the claim that Mr. Fisher did not comply with 3513.271. That section deals with candidates running as an independent candidate in the general election. Because if you want to be, so again, we look at the revised code, and those are the two copies of mine.
Well,
But I give you one copy for the board. No. Two different documents. Those are the revised codes I'm about to cite that you probably want to
Okay,
make.
I just want the board to have every revised code section either council mentions, so we can look at those.
So if you look, section 3513.257 declares each person desiring to become an independent candidate for an office for which candidates may be nominated at a primary election shall file, quote, a statement of candidacy and nominating petition, as provided in section 3513.261. 3513.261 provides what the form of the, quote, nominating petition and statement of candidacy shall be substantially in the form of. So again, when Mr. Colombo said the statute does not, petition is not defined in the revised code, it is defined. In 3513.261, it defines what is a statement of candidacy and a nominating petition. And so when one seeks a part, like I said, I mistyped here, but one seeks not to be nominated as a candidate in the general election, one files Form 3G, document entitled Nominating Petition and Statement of Candidacy. In the page 4 there of my summary, I've got an excerpt from that Form 3G, where you see, first, it's entitled, the overall document is entitled Nominating Petition and Statement of Candidacy. It then has the Statement of Candidacy, followed by the nominating petition portion. So if you looked at the full Form 3G, you would see that. And that's what the statute refers to, a statement of candidacy and nominating petition. And so when you go to 3513.271, the whole basis for Mr. Anderson's letter, it says, if a person desiring to become a candidate for public office has had a change of name within 5 years, immediately preceding the filing of his, quote, statement of candidacy, then both his, quote, statement of candidacy and nominating petition must contain the former names. That section applies when you are submitting a statement of candidacy and nominating petition, the form of which is set forth in 3513.261 and per 3513.257. A statement of candidacy and a nominating petition is used when a person is seeking to be nominated to appear on the general election through that process. In this case, the Form 289 does not involve a statement of candidacy and nominating petition. I'll say that again. Form 289 does not involve a statement of candidacy and nominating petition. They clearly set forth That is applicable only when an independent candidate is seeking a nomination to be placed on the general election ballot. There is no legal or statutory requirement that a political party, which is the entity that files Form 289, there is no requirement that the political party, in certifying its selection to fill a party's nomination for an office, or nomination for a candidate for an office, list any prior names of the person. Section 3513.31 simply declares that the chairperson and secretary of the meeting of the political party shall certify in writing the name of the person selected to fill the vacancy. Similarly, 3513.31 simply provides that the person who the political party selected, that certification must be accompanied by the, quote, written acceptance of the nomination. That's what 3513.31 requires. That's what's on Form 289. There was one interesting comment Mr. Colombo said, he talks about these other cases, et cetera, and the Gold case. All of those cases, all of them, involve situations where individuals filed declarations of candidacy and a petition. They were all seeking a political party's nomination at a primary election. All of those cases involve situations where people tendered the petition that is Form 2F. All of them. None of them involved a situation involving Form 289. And so when Mr. Colombo kind of said, well, those boards and the Secretary of State said, the board can't change the law, the remedy is with the General Assembly. I would submit to you it's Mr. Colombo and Mr. Anderson who want to change the law. The law puts no requirement that the Form 289 include any former names of the person selected by the political party. That is not a statement of candidacy and a petition. That's what the law, that's the forms that require the inclusion of prior names. So I would say, one, appreciate the overriding purposes that I talked about at the outset, that elections laws have to be liberally construed in favor of allowing the people, the voters, to choose their representatives. Additionally, that a political party is entitled to have a candidate for each office at the general election. And the final thing is, apply the law, but don't change the law. None of the cases involve this that Mr. Colombo relies upon. Those things, the law was clearly applicable because those candidates were seeking a party's nomination at a primary election. They filed the Form 2F. They did not include their name. The law says that. The law puts no such requirements when the party acts pursuant to 3513.31 to fill a vacancy in an already existing nomination. Thank you, Mr. Chairman.
Thank you. Mr. Colombo, you went a couple minutes over.
I knew I was going along.
No, that's my fault. That's my fault because I interrupted you a couple of times. Mr. Colombo, would you like to say anything in response to what Mr. Hartman had to say?
Just a few points. I'm not going to repeat everything I stated earlier, but is there an extra copy of the memo, Mr. Thank you, sir. All right, great, you're good. No, the only couple points I would make are the Secretary of State, as the board's well aware, has prescribed forms. And my argument would be that there is the Form 2F, which is one Secretary of State prescribed form when a candidate's running, but the Secretary of State has also prescribed the Form 289. But under either form, the revised code sections deal with petitions that nominate and include a statement of the candidate. So under either Form 2F, or which comes from an individual candidate running for office, or a Form 289, which is submitted by the party on behalf of the candidate, both of those forms include the same elements required for this law to apply. You've got a petition to the Board of Elections, both of those forms nominate, and both of those forms include a statement of candidacy. So, and again, I don't know how using a Form 289, a candidate could get around that law I cited earlier that you have a copy of now, 35-1302, about the boards printing the ballots. The public purpose still serves that the public is made aware of a name change. And if that information is not included on the Form 289, they would be printing that information without the former name. And again, I just would emphasize again, adding one more name to an existing name does not alter the way the law should be applied. It's any change of name, and that's what it states. So those are the only points I wanted to rebut. And I know there was a witness. I don't know if you want to hear from the witness and then.
Did you have the witness?
No, I'm not sure if, is he, Mr. Hartman, is he with you? No, so I'm not.
Well, neither one call, I mean, we can hear from someone, if he has anything he wants to add, but I would like are you finished with yours?
I am, Mr. Chair, thank you.
Okay, Mr.
Thank you.
Hartman.
Can I get about 2 minutes just to
Yeah,
address?
listen to me, I don't want anyone to feel rushed. I want this board to have the most information in a public setting that it could have. Go ahead.
Thank you, Mr. Chairman. Ms. Colbo said you have a petition with Form 289. No, you don't. There's no petition on there. You look at Form 2F, you look at Form 3G, the petition portion of the normal is when the individual voters are signing, we hereby nominate, we hereby support, etc. That's the petition portion. And the statute very clearly uses the phrase both a statement of candidacy and nominating petition. That is a unified form, that's the Form 3G. A declaration of candidacy and petition, that's Form 2F. Form 289 has no petition. Every time I heard earlier about the petition, I was like, where's the petition? And if you look at it, the statute says in terms of the certification on Form 289, it must be a, quote, written acceptance of the nomination. It's not a statement of candidacy. It's not a declaration of candidacy as used in the revised code elsewhere. It's simply, I accept the nomination of the party. And that's why if you look at the Form 289, the title is Certification of Selection of Candidate to Fill.
You're asking us to look at Form 2F or Form 289?
Well, I'm looking at 289, it doesn't say anything about being a petition. You compare it to Form 2F and 3G, it's a statement of acceptance. It's not a statement of candidacy, it's not a declaration of candidacy as used in the revised code. It's simply saying, I accept my party's nomination. Final thing, he mentioned the section that he invoked here, 3505.02. It's, again, that has, if you look, any former names which have been declared or submitted in accordance with section 3513.06 shall be printed on the ballot in parentheses directly below the present name. Mr. Anderson's letter doesn't even vote 3513.06 because that is actually for the primary election. They say 3513.271, so 3505.02 doesn't even reference the section that he raises. But again, you have to be subject to that section, be it 3513.06, 3513.270, which is the forms 2F and 3G. It's not applicable. The sections that they want to invoke do not apply. The cases they summarily summarize here don't apply because those were not statements or declarations of candidacies and a petition. This is simply a political party filling the vacancy. and the candidate accepted the nomination. Thank you.
Thank you. Mr. Colombo, did you want to respond to anything there?
No, Mr.
Okay.
Chair, thank you.
And Mr. Hartman, have you felt that
Yes,
we've
I
given
have.
you plenty of time? All right, thank you. And I think your name is David.
Yes, are you taking statements from concerned citizens?
We'll take any information that you think would help this board make an informed decision.
Okay. My name is Dave Skripak, live in Canfield. I would like to talk about the law in question regarding Tex Fisher, the rule to disclose any name change in the past 5 years. When the Founding Fathers wrote the Constitution and then Bill of Rights, they could not imagine the technology we have today or how society would change over almost 250 years. The Supreme Court still uses their words to interpret the law. Sometimes those words don't literally apply to today's circumstances in a way that is clean-cut, black and white. That is why the spirit of the law, or the intent of the law, is often more important than the actual words. I think that is what we have here. The spirit of the law, of this law, is to weed out bad actors, to prevent a candidate from hiding something in their past like criminal activity. This, of course, can be done by changing their name to such an extreme that the public cannot use normal due diligence to research one's past. There is no question Tex Fisher's name change does not violate the spirit of this law. In addition, the current Ohio Secretary of State's method for disclosing this name change law is not transparent and is extremely harmful to the voters' wishes of our state. Unless something has changed very recently, this law is not currently listed on the 33-page candidate requirement guidelines on the Ohio Secretary of State's website. There is also no space on the petition paperwork to list any former names. Secretary of State Frank LaRose and Governor Mike DeWine have been aware of this problem since at least January. So why are we here today dealing with this? Why are we here today? Because too many involved with politics don't put their community and country first. Because when many see a problem, instead of trying to fix it, they would rather use it as a political weapon to score political points. Because too many have a what's in it for me attitude. Or if it doesn't directly affect me, why should I care? Because too many in this country are just too damn selfish. Thank you.
Thank you. I have some questions. And since I'm the lawyer up here, I thought I'd help the board.
Thank you so much.
And I think this goes to your comment also. Are we bound by whether we put someone on the ballot by what is passed by the Ohio legislature? Mr. Colombo? Are we bound by the laws passed by the state legislature to follow their laws?
Yes, Mr. Chair.
That would be correct, yes.
Okay. Could either of you explain to me the difference between see, when they put too many things in front of me, this is what happens. 3513.06 and 3513.271.
I think I kind of did, I think in my summary,
3513.06 involves situations when a person files a, quote, declaration of candidacy and petition. This is on page 3 of my summary. The declaration of candidacy and petition is what one files in Form 2F. One files Form 2F when one is seeking to be a candidate for a party nomination at a primary election. So 3513.06 deals with those who are candidates at a primary election. 3513.271 deals with those who file, quote, statements of candidacy and nominating petitions. And a statement of candidacy and nominating petition is what is Form 3G. One files Form 3G when one is seeking to become an independent candidate for an office at the general election.
Okay.
So one deals with primary election, one deals with the petition, one files be nominated to the general election ballot.
Okay. Would you both agree with me that those laws were passed on August 22nd, 1995?
I have no reason to doubt that date.
Okay. In the same House bill by the same General Assembly?
Okay.
Okay. Would either of you like to make a comment about would either of you have exception with me saying that section 3513.31 was passed subsequent to either 3513.06 and 3513.271?
Mr. Chairman, I don't have the legislative history, I will take your word. I'll accept the representation that it was subsequent to.
It was passed in Senate Bill 193 in the 130th General Assembly on February 5th, 2014. So we have two statutes that talk about a name change passed in 1995. And then we have a statute passed subsequent to those in 2014. Would you both agree with me that there's no exception made in 3513.31? Any reference to 3513, either 3513.06 or 3513.271? In other words, the state legislature, the section I'm referring to is the withdrawal, disqualification, or death of a candidate prior to an election. Right?
Right.
That law was passed on February 5th, 2014, after the name change law was passed. Correct?
Correct.
You would agree with me, Mr. Colombo?
I would. I was just seeing if I brought several sections. I'm not sure if I brought that one, but my memory is it did.
And all I'm saying is, as I read this statute section, there's a couple of things I want to point out. It says the certification must be accompanied by a written acceptance of the nomination by the person whose name is certified. And it does not make an exception in 3513.31 for either of those two prior sections. In other words, when they created how you switch out a candidate, they didn't say, except as provided in this, or this section doesn't apply. You understand what I'm saying?
I think you're comparing apples and oranges.
Okay, how am I comparing apples and oranges?
Because firstly, you're wanting to write in, what your argument, if I'm understanding your argument or suggestion, is you want to write in a requirement into 3513.31 that the General Assembly did not put in there. The General Assembly could have very well said and included within 3513.31 a requirement that you have to include the candidates, any prior names of the candidate. The General Assembly knew how to write that into law.
Well, they didn't make an exception for it either.
Wait a minute, you're looking for an exception in something that's not even in the statute.
Okay.
It's an affirmative duty. You're trying to make a negative duty. It's an affirmative duty under 3513, make sure I get my sections, 3513.06 and 3513.271. The General Assembly there imposed an affirmative duty to list former names. Now you're wanting to say in 3513.13, because the General Assembly didn't put any affirmative duty in that section.
No,
You're trying to say there's no exception.
No, I'm saying that the state legislature knew that this statute was on the books and made no mention of this prior statute.
Because it had no application. Because
Well,
prior
did they
to-
have no application? But they used the word, you would agree with me, they used the word nomination. Right? The certificate must be accompanied by a written acceptance of nomination.
Right, and
Okay.
3513.06, and let me just limit it to 3513.271 since that seems to be Mr. Anderson's issue. 3513.271 uses the phrase, quote, statement of candidacy and nominating petition.
Okay,
The statement of candidacy, as it's laid out, the statement of candidacy and nominating petition is the Form 3G, by which a person seeks the nomination to be placed on the general election ballot. They declare, I am a candidate, and the following people say, we, the undersigned qualified electors, etc. That phrase, statement of candidacy and nominating petition, as used in 3513.271, is also used in 3513.257. Each person desiring to become an independent candidate shall file a, quote, statement of candidacy and nominating petition. It's used in 3513.261. The form of the, quote, nominating petition and statement of candidacy shall be substantially as follows. And that, from that statute, the Secretary of State issues Form 3G. That is what, that's.
so I want to understand your logic. So your logic is that if a political party submits a candidate, that's the candidate withdraws his petition, someone changes their name to Donald Trump, and then fills out a paperwork and gets the political party to appoint Donald Trump, that's totally legal under the
I
statute.
think you have an error in your premise, Mr. Chairman. The person does not withdraw their petition.
All right, say the person got promoted to a higher office, which happened here. Al Catrona got promoted to a higher office, the vacancy became unfulfilled. Someone in between Al Catrona getting moved from the state representative to state senate, runs into the probate court, changes their name to Donald Trump, comes in and fills out the paperwork you just said, that's totally okay under the law.
First, Mr. Catrona did not withdraw his petition.
Please
allow me.
Okay.
Mr. Catrona won the party's nomination by winning the primary election. At that stage, he was the party's nominee. He withdrew as the nominee of the political party. Then under 3513.31, the political party chooses who becomes their nominee when a vacancy occurs.
You and I are talking the same thing.
The statute.
Here's my
And
question.
under your scenario, there is no obligation imposed by the General Assembly upon the political parties who are choosing their new nominee.
You think, my question is this.
You're arguing a policy decision.
No, I'm asking this question. Under your analysis, if he withdrew his candidacy, Al Catrona, right?
And somebody out there previously changed their name to Donald Trump, either now, then, there is no obligation that the party identify a prior name.
Okay,
The law
so
does not
I just want to make
require
sure
it.
that's your position.
But your first question was, are we bound by the laws? The answer is yes. But the
So
law-
in that situation, where I think the state legislature, and I agree, by the way, 150% with the premise of your argument, that suffrage should be left up to the voters. I 100% agree with that. The Ungaro, I find it irony that you use our decision against us. But the court struck us down there. The court struck us down there because we didn't have what we're doing right now. We just ruled on our own without letting people have the benefit of a hearing. That's really what the court said.
I didn't even realize I was pulling the case from Mahoney County when I saw it.
We're all familiar with that case, and that's why we're having this inquiry today, because the Supreme Court sort of smacked us around, saying you didn't give people a chance to give them their process. And I'm making a ridiculous hypothetical, but the whole point of the ridiculous hypothetical is that could happen under your analysis.
Absolutely, it could happen, but as you appreciate, it's not the role of courts to interpret or apply the law the way they think it should be, or what the good policy decision would be. Their obligation is to apply the law as written.
Okay.
And not to add words, not to detract, and I think and again, I don't want to presuppose where you're at, but I think your questions kind of presuppose like, well, it makes sense that they should have their former names on the Form 289. As a policy decision, I can agree with you on that, philosophically, but as a matter of law, applying the law, when the legislature, because the legislature knew how to say, you have to put another prior name down.
Right.
They knew how to do it, but when they passed this 3513-31 in 2014 or 15, as you indicated, they didn't put that requirement in there And so don't write it in there.
Okay.
You can't write it in there.
So I understand your argument, and I want to get this right. So I understand your argument. You're saying that under 3513.31, it is not a petition for candidacy.
There is no petition. Correct, there is no petition, there's no declaration of candidacy, there's no statement of candidacy, there's no.
But would you agree with me that it says, I hereby accept the nomination as its party's candidate?
But if you look at the statute, I accept the nomination, and the form, the 3513 says, the certification must be accompanied by the, quote, written acceptance of the nomination.
Okay.
That's what that form is. It's not a petition, it's not a declaration of candidacy, it is in the language of the statute, in the language of the law, it is a written acceptance of the nomination. That's all it says, it's required.
I had an old mentor of mine tell me the only time we're not safe is when the legislature's in session. And I'm beginning to believe that because they have created a mess for us here, okay? And so I'm just trying to figure out what's right to do with my overriding principles, with my oath of office. Can you cite for me anywhere where the word nomination or petition is cited in the Ohio Revised Code?
And I will reference.
You know how sometimes they say, hey, here's what we mean by, when they're citing a statute, they say, here are the definitional terms we use in this statute.
Well, 3513.05 says each person desiring to become a candidate for a party nomination at a primary election shall file a declaration of candidacy and petition. So there, you're seeking the party nomination. You
No,
file
I
that.
understand that.
I know I keep repeating myself a little bit, but.
I understand your argument, I totally do. But I want to know, Mr. Colombo, is the word petition or nomination defined anywhere in chapter 3513?
Mr. Chair, not to my knowledge, and that is why, you know, the word petition, I think it shows that you have name changes covered in two different sections, right? 351306, 35.271. The intention, I believe, of the General Assembly is to cover all kinds of petitions. And as you correctly point out, there's nowhere defined in the revised code that a petition only refers to, you know, this section, and this section. The Form 289, I believe that's the correct number, is a form of a petition. And essentially it's a substitution of the original petition that was filed by the initial candidate. So it would be my view that this new petition, where 3513.271 says that both the statement of candidacy and the nominating petition, in this case they happen to be on the same form, I don't see the difference, and I don't see where the 289 form is not either or both a statement of candidacy or a nominating petition.
Would you,
Can
go
I-
ahead.
He just said he thought it was a substitution of the petition that the original candidate filed. That's totally wrong.
No,
When a
that,
can- when a
Wait,
candidate,
let him finish.
when a
Go ahead.
candidate files a petition, a declaration of candidacy or petition, to be a candidate on the primary election, all that does is puts their name on the primary ballot. Once they've won the primary election and certify the results, which is what we did on April 9th in this case, that petition is no longer effective or it has any role. All it did was put his name on the primary ballot. When he wins the nomination, he's now the party's nominee. And the control of that nominee, the nomination now is in the party when he withdraws.
So you're making I mean, you don't want to accuse us of being technical, but you're making the technical argument that this form is not a petition to us in any way, shape, or form.
It is not the statement of candidacy and petition as used in 2035. It's not a petition. It's not a petition. It is basically the party choosing its nominee and the candidate accepting the nomination.
Okay.
The phrase, the form where the statements, this revised code where it talks about including prior names, uses that consistent phrase throughout the process. Either a statement of candidacy, a nominating petition, or a declaration of candidacy petition, depending if it's a primary or a general election year.
would both attorneys agree with me that when a court cannot find a definitional term for a word that is used, that they go to the common parlance of the word, and many times, at least in my experience, they've pulled out a dictionary?
I would agree with that.
That is one methodology, though. I think you have to look at statutes in the entire context. You
I
cannot
agree.
pull words out in isolation.
Well,
And you
if
gotta look at the
they
entire
haven't
election
defined,
laws.
you would agree with me, they haven't defined the word nomination nor petition for us.
I'm looking right now just to try to confirm what exactly. I believe there is a definition somewhere of the term party's candidate. That's what I'm looking for in the revised code.
So if I look at the word nominate, it's to put forward as a candidate for a job or an award. And if I look at the word petition, this is my son's dictionary. Thank God for him, that he's away at school and doesn't feel he needs a dictionary. A formal written request signed by many people. Okay? So, in your position, the statute for a name change does not apply when a political party, for whatever reason, swaps out a candidate, correct?
I'm not sure I would say swap out. a
Well,
candidate,
well,
but-
well, what else would you say? The person dies, he resigns, he goes up to a higher office. I mean, the political party,
Fills a vacancy in the party's nomination.
that when a party fills the vacancy in a party's nomination, that the name change requirement does not apply. That is basically your bottom line position, right?
Based upon the clear language of the statute. I don't think
Okay.
you gotta go to dictionary or anything, you look at the plain language of the statute.
And Mr. Colombo, how would you respond to that?
No, I would disagree with Mr. Hartman. I believe. Yes. And I know we're getting a little repetitive, so.
No, I mean, this is the issue in the case.
Right.
This is the issue that I think people that get paid a lot more than we do are gonna have to make a call on. And I wanna almost in a way force them to make a call on this. Because I think this law, 35, I think the name change law is archaic. I think it's a stupid law, okay? But they haven't changed it, even after the 2023 decision by the Ohio Supreme Court, where they took a very hard stance against that statute. So I don't like the statute, but it is the statute that's on the books, and it's the statute that we're sworn to uphold. Whether I like it or not, there's a lot of things I don't like. And, you know, this might wind up in the Supreme Court, so let me editorialize. Supreme Court just ruled that boneless wings can have bones in them. So I don't know, that doesn't make any sense to me either. Okay, but they literally just ruled that boneless wings can have bones. So, but they're the bosses. They're the bosses of us all. I mean, and I ultimately feel that's where this issue should wind up, because it's going to force the legislature to either voice the change, okay, or tell us who's right in their argument. And so I don't know if the board has any other questions. I hate being placed in this position, but the legislature and the courts have placed us in this very position. And it's not hyper technical. It's what the law is, and I see some holes in the law. And I don't like the law. I don't like the name change law. Supreme Court even said it was a stupid law and to change it, and they still didn't do it. But it's still a law in the books.
If I heard you just say you saw holes in the law, and I think, I would maybe agree with you. And I think you're almost admitting that maybe you think the name change should apply to this situation, but I think you're also recognizing the hole in the law is the law doesn't require it in this situation.
No, I'm saying they don't tell us one way or another whether it applies. They say if you have a name change and you have a petition and nomination, that you gotta put it on. And I think the reason why they did the name change, maybe I'm reading too much into it, is so people don't hoodwink the public. And that's why I had the ridiculous example that I gave you.
And I agree with you about who, but wait a minute, they don't tell you what the law applies. I think they do tell you. They tell you by not putting it in there, they say it doesn't apply. That's telling you it doesn't apply. You're wanting to read it in there, you think as a policy matter, it
Well,
should be in there. And
because
that may be correct, you may be right, you may have the right policy arguments. But that hole in the wall that you referenced, what is there, because, where that is, they're telling you. And they're telling you it doesn't apply, because if they wanted to apply, they know how to say it applies.
And
And
they also
didn't say
know,
that.
they could also have said, except as provided in this section, and they didn't.
But those sections don't deal with party filling and replacing a nominee. Those sections deal with the petitions and the declaration of candidacy to get on the primary ballot or as a petition. And the petition is the individual voters signing. They've told you it does not apply by their silence. Don't read their silence as an ambiguity. And if there is an ambiguity, you go in favor of the voters having the right to choose their own. If there's an ambiguous, if there's a hole in the law, defer to the voters.
You are singing to the choir on that.
Defer to the vote.
We disenfranchise voters because they make us compare signatures. We disenfranchise 4 voters, and that was their signature. It's another thing the state legislature makes us do. Like, we're handwriting experts, and we have to examine handwriting. We had 4 people's petition, absentee ballots, we invalidated. We sent the sheriff out, and it was all 4 of those people's signatures. And so I don't like some of the things that the legislature makes us do, but they make us do it. Does the board have any questions? I kind of dominated it, but I was knee-deep in this stuff last night.
I've been knee deep for a couple of days, so I understand. No, I don't have any questions at all. But if you look at Mr. Anderson's letter, he does, in the second paragraph, he brings up the Ohio Revised Code 2513.271. And that applies to the statement of candidacy and nominating petition. So I don't know if we're gonna keep going around in circles here or make a motion.
Does Mr. Orange have any questions?
No, sir.
Does member Joyce Gilpest have any questions? No. Okay.
Mr. Chairman, if I may have a question, just procedurally, I believe the board did certify all other candidates to the ballot earlier this week, so I think what would be in order would be a motion
Yeah, that's what
to
I was just
certify
gonna
Mr.
ask.
Fisher and that the vote based upon the inquiry today.
That's correct.
Okay.
Okay, so the board now will accept a motion to certify Mr. Fisher to the ballot. Is there a motion?
So moved.
There's a motion made by member Sandra Barger. Is there a second?
Second.
Seconded by Bob Arndt. Do we feel we need any more discussion on
No.
this? Because I'm ready to vomit with all these revised code sections. And there's too many lawyers. Never hire a one-armed lawyer because then he can't see on the other hand. Would the director call the roll?
Ms. Barger,
Yes.
Attorney Beatrice,
This is a mess. No.
Mr. Arch,
Yes.
Ms. Gilpesta.
No.
Well, the Secretary of State doesn't want us sending down tie votes, right?
That's correct.
He's basically said, do not send me down tie votes, because I gotta make a call on it then. And that's where I think that call should be made. At the Secretary of State's level or Supreme Court level, that's where I think that's the reason. And I think that, well, let's try the vote again. Can we have another motion to certify Mr. Fisher to the ballot?
So moved.
There's a motion made by member Sandra Barger. Is there a second?
Second.
Seconded by Bob Arndt. Are there any comments, questions, or concerns besides everything we've already discussed? Hearing none, will the director call the roll again?
Ms. Barger,
Yes.
Attorney Beatrice,
No.
Mr. Arch?
Yes.
Ms. Calpesta?
No.
Does the board feel that if we took another 25 votes, that anybody would change their mind?
No.
So with the Secretary of the Board of Elections and with the Director, I will take now a motion that the Director send a letter to the Secretary of State with a copy of the, how fast can you get the transcripts done?
Not fast.
How much
Well, I think-
how much do you wanna pay?
I think Mr. LaRose should have everything so he can make a
That's
decision.
correct. I think both sides need to write
Correct.
an argument too, so you and Joyce and Bob and Sandy both need to document why you voted and how you voted.
Okay. So, would Mr. Barger and Vice Chairwoman Sandra Barger, how much time do you, I want to get this, look, we got to get this done fast. That's why we held the hearing fast. That's why we didn't delay. I think we could have everything, Misty, how long?
I think I could do by Monday.
Monday. Is that enough
Sure.
time? What are our drop dead dates for ballot printing?
Well, proofing next week, we have time if you get it done Monday.
Get it.
You have the calendar handy.
Yeah, remember, you can do anything you want. Congratulations, Mr. Schoolman. Well, so Sandy, I want you to revise your motion so we can vote on it. Member Joyce Calpesta said that I want your motion to contain how you want Mr. Fisher to appear on the ballot. I think Joyce is right on that.
I think Mr. Fisher has asked that his name is put on as Tex Fisher.
Right.
But if he doesn't have to have the former name on the nominating nominating form, then I wonder how he can use that name.
So I guess,
Because it's not his full name, and as you stated, the ballot has to state the full name, correct?
No, I did not say the ballot. Some candidates request to have their name Bob,
my
Which is
understanding
not
is they
right.
can use, you know,
Derivative.
a derivative.
derivatives,
But it all comes down
Samuel
to the-
Buck, Chuck, Matheny, how many middle names did Sam Buck?
But he had to change his name to use it.
I understand that, but the point is, so the record's clear. Could you put in your motion how
You made the motion, and
No, you made the motion.
Okay.
And so it's clear that he has sent us emails, my belief is, that he has sent us emails saying he wants his name to appear as Tex Fisher on the ballot. And is that your motion, that his name appear
That's the way it's
as,
listed on our paperwork here, I believe.
just so it's clear to the Secretary of State? Go ahead.
Does the board have a past practice or policy in terms of like a Robert asking to appear as a Bob, if derivatives of their name?
There are,
So the board has allowed that in the past?
I have no problem with that. The problem I have is I want to make sure when this record goes down, Secretary of State comes back and says, yeah, put his name on the ballot, and we have.
Now we're back at square one.
Now we're back at square one again. And, yeah, go ahead.
I think Tex has appeared on the ballot in Mahoney County as Tex already
Oh, yeah.
for State, Central Committee and as a write-in for the board and the school board, and we
Yep.
counted those votes for Tex Fisher at this
Right.
board,
So it really comes down to this Form 289,
Yeah.
where we always are.
And no one has raised this issue before,
No,
and he didn't win. It's the statute.
Oh,
he did win for the Central Committee. He's 1-1.
Wait a minute, hold on a second. Let me
Two
check.
separate committees.
Yeah, 2 wins, he's 2-1.
Hold on a second.
Pretty much, yeah. Pretty much that, yeah.
I want to just check something for you. See, I'm old. I'm older than Sandy even.
Oh, you gotta-
Sandy's much younger than me. Would either lawyer like to comment on whether or not a state central commit, did he win for state central committee?
County Central Committee.
Oh, county, not state.
Yeah, kind of,
Okay.
I misspoke.
He appears on the ballot in other counties.
Which is a public office.
Correct.
Well, would either lawyer like to comment on 3513.271, where it says, and has previously been elected to a state office, or,
It's not a state.
or a county, and it's not a county office either.
Nope.
It's a political party office.
Well, but there is an Attorney General's opinion that the County Central Committee actually is a public office, as in contrast to the State Central Committee. Because members of the County Central Committee do perform a governmental public function when they fill a vacancy at the county office.
That is true.
That they are, and that's when the Open Meetings Act is required, et cetera. So that, in that sense, being on this County Central Committee is holding an office of the
Did
state.
he appear on the ballot in Columbiana County? Because that
No.
entailed Columbiana also.
No, no.
So he ran for,
So-
to be a committeeman, right?
Correct.
And did he
In
win?
Mahoney County, yes.
And how did his name appear on the ballot?
In Columbiana County, did you also request,
I believe, I have to check, but I believe it's tax.
Well, just so the record's clear, if you would amend your motion.
So
So,
what did I say?
you just said to put his name on the
Just certify
ballot.
him to the
He wants
Okay.
his name as Tex Fisher.
Okay,
So I think that, so the motion and the record is clear. If you would amend your motion to say, I hereby certify to put
I
Mr.
certify,
Fisher
put Tex Fisher.
as Tex
as-
Fisher, Tex Fisher as a ballot for the,
State Central,
okay.
state representative.
There's a motion made. Is there a second by Mr. Arndt?
Yes.
There's a second by Mr. Arndt. Could the director call the roll?
Ms. Barger,
Yes.
Attorney Beatrice,
No.
Mr. Arch,
Yes.
Ms. Gelfesta.
no,
Okay.
Mr. Chairman, that should clarify for the records for the Secretary of State as well.
Yeah.
I think if I understand though, the opposition is not so much in terms of his name, how his name appears on the ballot.
No,
It
that's
is
not-
purely
no.
him appearing on the ballot under any name.
it's the truth.
I think the opposition, go ahead, Joyce.
I think it's the form in question. Whatever the
I
name
think
was.
that the official name change.
But it's not, we think his name should be different on the ballot. The opposition is, he shouldn't be on the ballot under any name,
Correct.
just so the record's clear.
Well,
I believe that they believe that the form number 289, which was filled out due to the Mahoning County Republican Party replacing Al Catrona, that's the form that they're saying applies to the Ohio Revised Code 3513.271.
That's where I am.
Wrong form. Sorry. Well, we used the right form, but we didn't, it's not part of the Ohio Revised Code.
okay. And so we took a vote on that, Annie?
Yeah.
Okay. And you can't have these done until Monday?
It's Thursday.
Well,
I'll try my hardest, but I do have.
all right. Do you think Monday we can have our letters done?
Well, can you get your letter done? I can get my letter
If I
done.
were him.
I'll just add it to the jury trial, the 9 jury trials I have before the
So
end
then
of the
Joyce,
year.
can you get your letter done?
Did somebody call the judge for you?
I think he's got
Tom, you're
time.
gonna call Judge me.
Deputy's not here.
Okay, is there any other, where's my agenda item? Thank you. I'm gonna open it up, is there any public, well, no one signed in to be a public, and this is a special hearing. I don't think we have to have a public hearing. So the next scheduled meeting of the Mahoney County Board of Elections is set for Tuesday, September 3rd, 2024, at 4 PM in the boardroom of the Mahoney County Board of Elections Office, 345 Oak Hill, Youngstown, Ohio. I will now entertain a motion to adjourn.
So moved.
There's a motion made by member Joyce Kelpesta. Is there a second?
Second.
Seconded. Is there any comments, questions, or concerns? Hearing none, would the director call the roll, please?
Ms. Barger,
Yes.
Attorney Beatrice.
Yes.
Mr. Arns,
Yeah.
Ms. Galveston.
Yes.
This meeting is now adjourned.